And here are some of the top trending stories this week. We begin in the Federal High Court, Abuja, where Justice Nnamdi Dimba has ordered that hearing notices be served to absentee defendants in the suit to stop attempts at removing the President of Senate Dr. Bukola Saraki from office, noting that the absentee defendants cited in the suit are yet to file their papers, thereby causing the case to stall. The court also ordered substituted service of all processes on all the defendants in the suit, filed by two former All Progressives Congress senators, Rafiu Adebayo and Issa Misau. The Federal High Court had previously assented to the accelerated hearing of the suit, seeking to stop any attempt to forcefully remove Dr. Bukola Saraki as the Senate President. The case has been adjourned to the 19th of September for hearing. In another case, the same judge, Justice Nnamdi Dimba, stated that its orders on Multichoice is still binding until the case is set aside. This is coming after Defendants Counsel Babatunde Irukera told the court that an appeal had been filed at the Court of Appeal. Justice Dimba had earlier granted an injunction restraining Multichoice Nigeria Limited from implementing its recent hike in DSTV subscription rates. The court also restrained Multichoice from any conduct capable of interfering with the investigation process of the Consumer Protection Council. The case was adjourned for continuation of hearing. Staying in Abuja, in the case of the Department of State Services, DSS, versus John Abiri at the Magistrate Court, Justice Chukwuemeka Nweke adjourned the hearing till September 17, 2018, to enable the DSS prepare an appropriate response to a motion filed by Jones Abiri's lawyers questioning the jurisdiction of the Magistrate Court to hear the case. Justice Nweke stated that despite the fact that the Department of State Services had two witnesses in court and had served proof of evidence to Jones Abiri 2 weeks ago, the issue of jurisdiction has to be addressed first. The Department of State Services had in July accused Jones Abiri of bombing oil pipelines, planning attacks in Abuja, and threatening international oil companies. According to the motion filed by Jones Abiri's lawyers, the offences he's been accused of allegedly happened in Bayelsa State, and as such, the case should be tried there. The Economic and Financial Crimes Commission has challenged the claim that the sum of 1.6 billion naira linked to a former aide of ex-President Goodluck Jonathan was a donation to the Anglican Communion of Otuoke Community, Bayelsa State. At the resumed hearing on Tuesday at the Federal High Court sitting in Lagos, the Commission asked the ex-presidential aide, Dr. Waripamo Owe Dudafa, to show evidence that any part of the 1.6 billion naira lodged in the Heritage Bank of a firm, Avalon Global Property Development Company Limited, was transferred to the church. During cross-examination, the EFCC lawyer Rotimi Oyedepo presented Mr. Dudafa with the statement of account of the property development company, asking him to point out if there was any money transferred from the account to the church.
And it's on that note that we end this week's edition of Law Weekly. Please feel free to send in your questions and comments on any of the issues we featured today. And remember that you can watch this episode and past episodes of the program on your YouTube channel. I'm Millicent Walker. Thank you for watching.